Hi everyone, it's Grant Abbott speaking. Welcome to this launch of our new product, which is our Discretionary Trust upgrade to Leading Member Trust. And we've also got a Leading Member Trustee company up and running. There's a couple more variations that I need to put into this system, plus a strategy automation, which will really bring everything together. Primarily for this, if you haven't had really a big intro into leading members or not dealing with it, there's lots of resources on our support centre. There's also letters to go out to clients in relation to that. We've got our conference, if you can attend that, on the 23rd and 24th up here at the Novotel in Sunshine Coast, which goes for 2 days. So it starts on a Monday and Tuesday, so it gives you a lovely weekend beforehand at the Novotel, and we've got some really great deals there as well. But if you come out of that, you're really going to understand a lot on leading members. Also, if you go to I Love SMSF, you'll find that there's a blog, or you can go to Spotify, go to I Love SMSF, and you'll find there's a great half-hour session I did with one of Australia's leading proponents on leading member, and that's John Grokey down in Adelaide, where I discussed how he talks about it with his clients. In fact, he's coming up on the 23rd of March to give a face-to-face and show how he actually does or deals with leading members. So he's going to take you through that client interview. So if you can get there, it's definitely going to be worthwhile, and will really take you leaps and bounds along these grounds of succession and also estate planning. So for those of you who want to put your hand up, we're all going to be on that day forming an association, which will be the Association of Succession and Estate Planning Advisors of Australia. So that will be very, very exciting. So hopefully I'll see you all there. Now I get, and I think if you've read a couple of my emails recently, I think the first ever trustee that I reviewed was way back in about 1986, probably 1986, when I was doing a Masters of Law with Professor Richard Van Graham Cooper, Ross Parsons, also Rob Deutsch. Like, these four guys are absolutely brilliant. And we had case studies, which they'd been going for a long time. The case studies looked at specific areas of the law, and they hadn't changed for like 30 years. And what happens is the facts stay the same, but the laws change around it, as we all know. I mean, if we have a look at, I remember when I first started doing tax law at KPMG as a tax consultant, I think there was only like one small volume of income tax laws altogether. Now I've got like a great behemoth of a book just around superannuation. So things change, and you can really see that in Discretionary Trust. The old one I remember looking in 1986, and I've seen a couple just recently that go right back to the 60s. There's really not that much in them per se. They're pretty blank. They really haven't kept up to date with the times. But they're still apparent. I mean, we don't necessarily want to close them down. I mean, look, I have seen instances where discretionary trusts have been closed down. There's no capital gains tax or stamp duty consequences, and the new trust has been established. But generally, we don't want to go through that process because we might end up with capital gains tax and stamp duties. Bamford was a big case, and most of you guys know about Bamford and FCT, which looked at, what is income, the proportionate approach, and more importantly, the ability to stream different aspects of income. So that came out in 2010. As you can see, it's a High Court of Australia. So you really, the Commissioner couldn't really change there and couldn't give guidance about that. Was giving a lot of guidance on the way up to the High Court decision. But then was sort of blown away with the High Court decision and sort of taken on the chin, which is not a bad thing. Now, there was a mad rush to upgrade trust deeds at that time, and of course, obviously, the issue of resettlement was like a sword of Damocles hanging over everyone, because to go in and potentially change the income streaming provisions, maybe even adding to or taking away from the beneficiaries. Really, everyone, the big talk about it was resettlement. I know that Tony Anamoulis, my tax partner from Abbott-Family, has had a lot of experience in this, and we had a look at resettlement. I think it's drilled into your minds when you do equity law at a university. They've got to be very careful that a new trust is not created. Not that it's a big issue, but that, again, it means we're closing the old trust down and setting up a new trust, which means that obviously there's a transfer of the existing assets over to a new trust, which would result in a capital gains tax and potentially stamp duty issue. We're very lucky, though. I think obviously at that time the Commission issued a ruling which really, from our perspective, sort of made sure that we had a particular issue that we had a particular issue at that time in terms of resettlement, and he came out with a determination, TD 2012/21, which we're going to look at in detail in this session, so that it gave comfort around Bamford, and really that you can make quite substantial upgrades to the rules of the discretionary trust, and we're going to use that for the leading member discretionary trust. Now, I know I've got Tony on, and I'll bring you on a little bit later, Tony, so thank you for getting out of court and coming today. So the leading member trust package, we'll have a look at that very shortly. The key issue there for us is, why is the leading member discretionary trust different from an ordinary discretionary trust? And I would say, look, if you looked at it straight in the face, there's a few small differences, but really it's a conceptual difference amongst all of the whole package, which I'll talk about. But really, I did see an old family trust the other day. Well, not old, it's probably about 10 years, 15 years old, where there was a chain of appointors. It's not a bad thing, a chain of appointors, because that effectively gives us succession, which we're going to have a look at shortly in terms of a case study. The leading member discretionary trust, as we'll see when we actually build one for this case study, has an ability to limit beneficiaries to lineage or bloodline only. Now, if that's not the case for your clients, then you don't want to be using the leading member. If you're comfortable with where the current discretionary trust is, if you have got succession issues or you want to put in more succession, then you'll see when we get to the trust section of the LightYear Docs site that you can actually put in just a succession of appointors over the existing discretionary trust. And that won't amount to a resettlement. But if you really want to go down the leading member route, so that you do limit to lineage or bloodline, the leading member appointor, notwithstanding you're a trustee, has veto over all of the trustee decisions. And if you've got ordinary trustee or you've got a corporate trustee, the leading member appointor is the chairman of those, which at the end of the day, you might put in other directors, but at the end of the day, the leading member appointor has complete veto or control over it. So that's not a bad thing. Certainly you would not be using this sort of company if you've got a unit trust that an SMSF invests in, like a SUIT, which is the superannuation unrelated investment trust, which is primarily that no one controls it. Obviously, if you have a leading member corporate trustee with complete veto power, they control it, so that whoever's SMSF the leading member appointor belong to would effectively be an in-house asset. Protects everyone else, but not that. So what we're doing is we're really seeking to control this whole process, not only now, but we're building it, for potentially 30, 40, 50, 80 years. Most of you know the rule against perpetuities lasts for 80 years. In South Australia, the rule against perpetuities is excluded. It's not included, so that if you choose your jurisdiction as being South Australia, notwithstanding you might have trustees in different states, etc., then effectively the rule against perpetuities will not apply. And that's been very useful when we come around to doing testamentary trusts. But again, it's all very well having all of this. So we've got this beautiful package that we'll look at, which is we've got this leading member discretionary trust, we've got bloodline beneficiaries, we've got this, we've got that, etc. But it's still going to be that corporate trustee, which potentially is an issue. And I know many of you have corporate trustees, and they can be very problematical. So let's have a look at a quick case study. I've got John Smith, who's age 57, is the sole appointer of the Smith Family Trust that was settled in 2007 and updated in 2011 for Bamford. So this is pretty typical. You know, they might have started earlier, they might have had like a whole list of upgrades there. One thing I would say there, and this is probably one difference for LightYear docs compared to anyone else, is when you do your docs, and most of you are aware of it, and I'll look at it a bit later, is that all your docs are automatically included in a vault. It still surprises me that many online document providers or anyone doesn't have vaults there that, you know, you've got to link up to some like G Drive or whatever. You really need to be able to go in here, not only have a vault, be able to go and change that documentation at a later stage if circumstances change. I think that that's absolutely crucial, because more often than not, we're getting quite a lot. In fact, only in the last 2 days, I've had 3 requests from people who have gone to banks or can't find their original deeds or the actual copies of the original deed. And that in that instance, banks have basically knocked them back, or there's problems with the loans, which means we really need to go through the upgrade process anyway, so we can get a documented variation there. Whether the bank goes back and looks for the original is going to be depending on which bank you're looking at. From that perspective, so we've got, it's all updated. We've got the documents, they're all okay. The trustee's a corporate trustee with his second wife, Sally, and he and her are both shareholders and directors. They run the business out of the trust, so this is his second wife. He expects and wants it to continue on, subject to his wife's decision post anything happening to him. So she might decide to sell the business, but then again, she might want to carry it on. So the trust also owns a factory in which the business runs out of. There's also a bucket company which has $1 million in cash and franking credits, plus Division 7A loans to shareholders, John and his wife. Now, this is the key. His estranged daughter from his first marriage has threatened on numerous occasions to challenge the trust if he died and get her hands on the business, which she wants basically sold. So when we have a look at that, I mean, that's a key area for us. And we have a look at this structuring program for succession. So if I'm just looking at this discretionary trust, or you look at discretionary trust just by itself, then you say, well, there's not a drama around that. There's no difference between leading member appointors or leading member trusts, as long as I've got this chain of, you know, different appointors coming in through here. You've got the bucket company. It's not a big issue, but there is an issue when we go back here and we have a look at the Family Provisions Act, because what will happen here is that on the death of John, let's say John died yesterday, so, you know, we've got Sally coming in your office, and, you know, she's in tears because the young daughter is, you know, has got a lawyer, and they're threatening and they're challenging, and they want to take all of the, you know, as you can imagine, they want to get their fair share of all of the assets. They're going to do a family provisions claim under the New South Wales, or could be in Queensland, the Succession Act, or Western Australia, the Family Provisions Act, and they're going to make a full claim on it. Now, the issue about that is, where do we go with this? I'll go back to the case study. What do you think is at risk here? So we've got the sole appointor. So that's a problem for the first issue, is that, you know, there's only one appointor. The appointor has died. So we need to go into the trustee to the fund to find out who can appoint the trustee. And of course, generally, if that's the case, we find out, as usually, if there is no appointor, it's usually the trustee that can change the trustee, but of course the trustee may or may not change. So if we have a look at it from that perspective, we may be in a position that Sally can effectively just keep the, sorry, I went the wrong way. Sally can effectively keep the trustee. The danger about it is what? The main danger is on death. This, if it's untreated from a moat or family protection purpose, ends up over in the will. Plus the corporate trustee, or the shares that are held by John, end up inside the will. So then we've got the executor, and let's say Sally's the executor. What will happen there is the young estranged daughter of John and their lawyer will now start to attack Sally. In effect, what they will be seeking, if I was their lawyer, they will be seeking that all John's shares in the corporate trustee and 50% of the shares in the bucket company should be transferred to the daughter. Now, they'll probably, in fact, not go 50, they'll just go, well, we want absolutely everything, 100% of the shares of the company. Now, that puts a lot at risk because one is if they make that attack, then it means that the existing discretionary trust which holds a business now has the sword of Damocles over that business, because the lawyer there, if they control that corporate trustee and then effectively have a shareholders meeting, at the shareholders meeting they can oust all the directors, then it means effectively that Sally might get booted out and the young daughter ends up with the business. Now, of course, that's going to take a long time when we go through that process, because there's a lot of issues, continuing businesses, etc. You know, I'd be saying it's going to take maybe 2 to 3 years to resolve this particular issue. And I would say upward, depending on how successful, like the business is really turning over a lot of money, I would say it's probably going to cost maybe $400,000 to $500,000 in fees and also litigation. The other side of that one is that the bucket company also, if they take that, and remember there's a loan to both John and also Sally, if they get the shares in the bucket company, make themselves directors, they may decide to call in that loan. So that John's share of the loan would actually come from the estate or whatever's in the estate. And then obviously Sally would have to find out where that money is. So you can see simply from the death, and we've got these two companies and one's a trustee company, that whole discretionary trust just starts to look pretty ugly. And look, I won't go into the SMSF, but you know, it's the same sort of thing. If there's a trustee company here and that ends up there, again, they're both going to be locked out, which is essentially what we want to do when we have a look at our leading membership, and I'll look at that as well. So I'll just see, I've got Tony there. Are you there, Tony?
I am.
Do you want to, I mean, you have obviously seen a number of cases recently in terms of estate planning where there's been lots of challenges, but certainly under the Family Provisions Act, I'm not sure what you have down in Melbourne, but they're all through the Supreme Court. So what are typically the costs involved in that sort of process?
Oh, they could vary. I mean, you know, one typical challenge would cost, once you get into the litigation stage for challenges in wills, you know, that could exceed well over, you know, 100, 200,000, you know, which is ridiculous at the end of the day. You know?
Well, I certainly know that Taylor and Miller case over in Western Australia, which was only a $600,000 estate, that was eaten up by $500,000 of legal fees, so that the family provisions claim that the court made on behalf of the second spouse as against the children from the first marriage, the family provisions claim was irrelevant anyway because it was all taken in legal fees. So it's interesting when we have a look at these sort of case studies that we think that we've got asset protection for our discretionary trust, but it's really what happens on death. And the other issue, of course, is divorce. It's exactly the same sort of thing. Let's say that we end up with John and Sally divorcing. John is the appointor there. That could actually slow down or really create huge problems around that trust, because obviously the family lawyer is going to want to start to attack that. So let me go in and have a look at how we are going to look at this, and more importantly, look at it from a practical perspective. The first thing that we need to look at is the ATO determination, which I'll take us through shortly. We'll look at key succession issues at leading members, look at the bloodline issue, and then we need to see if that really conflicts with what the client wants. So if you're using a leading member, we'll go through the beneficiaries. Bucket company, we need to work out how to handle that separately. I'm looking at discretionary trust. We won't look at bucket companies at the moment. Then I want to take us to the leading member, a trustee company, And this is not for SMSFs. This is quite a separate one for discretionary trust. And I want to show you how it works in the event of death, divorce, retirement, resignation, dementia, and the necessity of cleaning up the shareholding before the upgrade. So let me just bust out of here and let's go and start to have a look at the Commissioner's guidelines. So I've got this determination. This is actually being recorded, so it'll be available for you later on today. And I'll send out links to this determination, plus obviously the slides as well. Of course, like all of our stuff, it'll be up on the support centre. So again, this really comes out of Bamford, but we can still take it to date. So does CGT event E1 or E2 in sections 104.55 and 104.60 of the Income Tax Assessment Act happen if the terms of a trust are changed pursuant to a valid exercise of a power contained in the trust constituent document or varied with the approval of a relevant court? So first and foremost, it's absolutely crucial when we do look at a variation, we need to ensure that the deed can be varied. It's quite surprising. I had a look at a case the other day and I was actually very surprised because it was a major legal firm around that had a discretionary trust deed. And this is one that many of you probably got if you've been doing some online ordering. And in there, the client wanted to vest the discretionary trust. Now, blow me down, I had a look through the whole deed, and there was the only way to vest or wind up the trust was at the end of the perpetuity period, which was 80 years, or if it's in South Australia, you can never wind the thing up, which came really as a surprise to me. So for that one, this determination really becomes absolutely crucial, because what we'll be looking at there is upgrading the discretionary trustee, and we can do it either through an ordinary discretionary trust or the leading member, and then obviously having to go through the process of using the winding up or the vesting rules, which are built into those new rules. So again, you just really got to make sure, go and have a look. The first port of call for us is when you do have a discretionary trust that you go and you want to vary, have a look at what the requirements are to vary. Is there a principal, often the appointor, and appointor required to sign off in terms of variation? Anyway, we've got here is if there's a change in the trustee or really the terms of power, is that a CGT event? Now, I'm just going to focus in on CGT in this section. I know that we've got a couple of very smart people on, such as Milton, etc., and Ian as well over in Adelaide. I'm going to have to go and do a lot more research in terms of the stamp duties, if we change fisheries, etc. There shouldn't be any sound issues, Michael. If everyone can just put their hand up if they're hearing it correctly. It may well be the internet at your end. I know, Tony, there's quite a few people, so they were saying that the sound is okay. So it might be your sound, Michael. If not, if there's an issue, just simply drop off. And remember, this is going to be recorded anyway, so that'll be fine. So the Commission said no, so there's no CGT issues. In these circumstances, neither CGT event nor if we have a look at neither the CGT event happens unless the change causes the existing trust to terminate any trust to arise, or the effect of the change of corporate variation, such as the lead to a particular asset being subject to a separate charter rights and obligations must give rise to conclusion. So, I mean, that sounds a little bit like gobbledygook, but again, let's go and have a look at the examples, which, you know, hats off or hat tip to the Commissioner on this one, because he does go through a few examples. So let's have a look at addition of new beneficiaries. So the Acorn Trust as a family discretionary trust was settled to the benefit of the Squirrel family. In terms of the trustee, a private company which Mr. and Mr. Squirrel are directors has an absolute discretion to appoint income to one or more of the general beneficiaries. Beneficiaries defined on the terms of the trustee to be Mr. Squirrel, his wife, their children, their grandchildren, a private company through which the family runs a business. So it's a bucket company, it's typical. Through this, I suppose they're interested in nature and unrelated third party. The trustee for the Acorn Trust provides for the trust to be amended, namely by trustee resolution or court in writing. Due to this procedure, the trustee resolves going to amend the specific remove writing by name from the class of general beneficiaries. So, for example, if you actually have established a leading member discretionary trust right from the outset, and we've got either bloodline or lineage, you could actually exclude bloodline and just look at lineage. Now, the difference between bloodline and lineage is bloodline goes up, sideways. Anyone who's got the blood of the leading member appointed is included, whereas lineage actually means it's the leading member down, it's their children and their grandchildren, and any entities they're involved with. So there's quite a significant difference. So the trustee resolves to as a class general beneficiaries, respective spouses of the children, trusting companies, charity, unrelated squirrel family. Now, normally, most of us would say, oh, God, that looks like a resettlement, because that's a pretty major change in the underlying terms of the deed. But we've got here, the making of these resolutions by valid exercise of power amendment contained in the deed does not give rise to the happening of a CGT event. Expansion of the power to invest. Again, have a look through this again, but they opened it up, the report, the change of power to invest, again, doesn't have an impact. Addition of definition of income, power and extension of vesting date. So I'll go on this one because this is, again, pretty important. The Line Trust is a discretionary trust settled in 1980 to benefit the members of the Linden family. The trustee contains no definition of income, nor does the deed contain a provision permitting the trustee or the trust to stream income. So obviously it's not, doesn't match up with Bamford. But again, as I said, look, 1980, you don't expect a 1980 trust deed to really match up with current and modern thinking in terms of trust. So the deed contains a clause specifying the date at which the trust is vested, 30 September 2020, if you had accurate income, it's right. So pursuant to an unfettered power of amendment in the deed, the trustee resolves in writing to amend the deed to insert two clauses. So as you can see, we've already got a position here. The tax office is saying it can vary these deeds. The first defining income of the trust equal the net income of the trust as calculated in section 95(1), excluding franking credits unless the trustee otherwise determined. And the second, authorising the trustee to separately identify and label various sources of income or receipts that form part of the income of the trust estate and to deal with those amounts referenced their labelling as to stream. So again, that follows Bamford. The trustee further resolves to amend the deed by changing the vesting date to 30 September 2050, which really that follows. So that's probably they could go. If it was in 1980, it was 80 years, they could have actually gone to 2060, which you'd expect. But the making of the resolutions being a valid exercise of power does not give rise to the happening of the CGT event. I won't go through here because, again, we can extend the vesting date if we choose to do so. It'd be interesting to see if we change the jurisdiction, how that would go. So there is no vesting date. This is the important one. The Hedgerow Trust is a discretionary trust, a class of objects of which consists a large number of entities associated with the Buttercup family. Under its terms, the trustee has a wide range of powers, including power to declare that particular assets of the trust are to be held exclusively for one or more of the trust objects to the exclusion of other objects of the trust. In exercise of this power, the trustee declares that one of the several assets forming part of the corpus of the trust, asset one, was henceforth held exclusively in trust for one of the objects, Mr. Badger. 1 month later, the trustee makes a second declaration, so it goes in favour of Mr. Badger in respect of one remaining assets of the Hedgerow Trust. While the respective declarations do not terminate the Hedgerow Trust, the effect of the declaration that assets 1 and 2 are no longer held on that trust. Rather, the trust obligations attaching to those assets have changed in a manner consistent with the conclusion the assets have commenced to be held on the terms of a separate trust. So what I get out of that, and I think that it's pretty important, is that really we can go and change the powers, we can change the vesting date, we can effectively also change the beneficiaries, the income, the streaming, but where we take an asset out of the existing trust, if we're able to, and set up a new trust, that new trust will be a resettlement. And Tony, are you there?
Yep, I'm here.
Yeah, so we sort of went through and discussed last week in one of our partner briefings around 2004/21. It's great. It's a great find by me. I had tips to the commissioner, but certainly it's a lot wider and gives us a lot more comfort in terms of there not being a resettlement where we almost do a variation, much the same as we have with an SMSF deed. We can throw out the old and bring in the new. Just be careful of loading up an asset into a separate trust.
Yeah, yeah. So if you're not really making any substantial amendments to the trust deed, well, you're okay. You're all
I know,
good.
it's perfect. So let's jump in and have a look at the leading member pointer and where we're going with that. So what I did here is I actually got the discretionary trust. If I want to look at that, I'm going to go into my vault. So remember we talked about the vault that is necessity. So every document you do on the site is actually included in the vault. And you want to make sure that you have all your various clients there. So the one I did was in the grant test. You can see here we've got a discretionary trust variation. That was only done, on Queensland time, so 10 minutes before we actually started. So I'm changing discretionary trust to leading member discretion. So what I do there is I can either download it or I can relaunch it. So by pressing that little rocket, I relaunch, and that now gives me the whole system here. So it's a very powerful tool because particularly with some of these documents, we can always go back and preview the documents or have a look at the answer summary. But the main thing from our perspective is that we can prepare these documents before a client comes in, and then when they come in, we can then go and do any finalisation before they go through the sign. So again, what I've done here is I've got the name of the document. So this is in bold, so I know where it is. I've got the AM001 tag. Now that is the Abbott-Family logo. Feel free to use that. Or alternatively, none of our LightYear Docs product suite have LightYear Docs on them. Otherwise, it's too easy for a client to go and say, well, gosh, you paid this amount of the LightYear Docs. The main one is all signed off by Abbott-Family, which is absolutely crucial. And then more importantly from our perspective is that if you are on one of our subscriptions or one of our licensees, you can send your logo to us and then you can put your own logo on that document. So we go through the general. I've got the Smith Family Trust set up on the 5th of October 2007. It was New South Wales. We've chose to apply the agreement. I've put in there was no charity before, but I've actually introduced RSPCA, and I'll just put New South Wales there. So that's my new charity. And remember, I can add a charity, and that's not going to change the resettlement. I've had a look at the current deed, and the ability to upgrade the rules is 4.7. I'll come back to that a bit later on. There's been another update. So what we want to do is put the chain of variation. So I've gone through and I've had a look. There was another variation on the 4th of April 2011. So I put that in there as well. That gives me the chain of variations, which then attaches to that. The next one, I've got the trustees. So I've got my company there, etc. The company was probably would be a typical general company from that perspective, which is fairly typical for trustee companies. I think up until recently, or my trusts, I've always had just a general ordinary company acting as the trustee. That can be a bit dangerous now, given what we looked at in terms of the John Smith case study. We want to put in place a leading member corporate trustee, which I'll look at probably in about 10 minutes' time. So what we have to do is, if we've got an existing company, we just need to upgrade that constitution to a leading member corporate trustee constitution. You can't use the SMSF corporate trustee, obviously, because that is specific to SMSFs only. We have got a variation solely, or an upgrade solely for leading member discretionary trust. So we've got John and Sally both there. So again, this straight out of case study. We've got the leading member. So is the leading member a joint appointer? I've got no. So what I've done is I've worked out the leading member appointer. I've set the down with John. John's the first, then it goes to Sally. Now, what happens if Sally's not around? Because we've got some longevity here in terms of this trust. John has chosen his brother, Bruce Smith. So if they're both not around, then Bruce becomes the leading member appointer. I'd highly recommend you go down at least 3 levels. And if you've got the children in there, again, you can make them joint if need be. And then you'll have to work out who gets a binding vote if they're equivalent. So we've got the leading member being an individual, being John Smith. I've then got, you can see here, the second leading member appointers. Is that going to be, I've chosen yes, I'm going to appoint one. Is it joint? No, so we've got Sally there. In the event of the death, incapacity, a second leading member, do you wish automatically a third? And I've gone yes, and that pops up with Bruce Smith. The beneficiaries, is there a company? Yes. Is there a unincorporated association? No. So I then go through the corporate beneficiary. I've got the Smith Bucket Company, all of that. So that what we're doing is we're embedding in the new variation, although that was the bucket company of the original one, we're now throwing this and making a specific beneficiary of the trust. Again, it's not a resettlement according to the Commissioner. So we've gone through that. Is there another person required to sign the deed? Well, yes. So we've gone through and had a look at the variation clause, and it basically says that the trustee can vary, but it needs the consent of the appointor. So what I've got here is yes, and I've got John Smith, who is the appointor, needs to sign. So I've got there the appointor. It could be the founder. A lot of the ones actually call them principals, which is either or, but principal generally is the appointor, the person who has the power to choose the trustee. The leading member appointer is different. You'll see, because they can actually choose the beneficiaries as well. So we go down there, we finish it, and then that's the process. So this is the behind the scenes, the legal precedent material we've got. We've got a few good documents coming up down the track. I still have to finalise this leading member suite, so I'm going to punch out this here, so it comes out in the PDF. And again, this is coming out in a draft for you guys. So a discretionary trustee, you can see there's the Abbott-Family logo. If you'll put your own logo identifier up there, then it comes up as your logo. So discretionary trustee, variation of the Smith-Family Trust, a leading member discretionary trust. We've got it all signed up by Abbott-Family. So the deed is dated the 5th of October 2007. That was, okay, so I've got to make a quick change on that one. So we picked up that date needs to obviously be fixed up. So that was my fault in terms of what I basically put into the data. So what we have to do from that is, if I want to make the change, generally I'd leave it undated, and then when the client came in, what I would do is I'd then put the date the client comes in. But that's an easy process, because I do is just go back in and, as I said before, I just have to go here, and then I go back into my vault. I go back into my folder, because I know it's a Smith, and then I could just simply go through and see this one's changed. I could simply go through and relaunch. So it's not a difficult process that we're going through there. So let's have a look at what we've got. We've got the discretionary trustee. The key issues that we've got, in fact, it's this one here. So the leading member appointor is John Smith, and John Smith's the current appointor there as well. So the trust was established on 5th of October, varied on the 4th of April, which we said. The purpose of the variation is to create a succession of leading member appointers and update the trustee's powers. The trustee will not change the current vesting date of the trust. The appointor is agreed to act as the leading member appointor, so we'll just simply really change the name. The variation of the trust rule will meet the Commissioner's determination on varying a trustee without a new trust or settlement arising. The appointer provides their consent. So if there's no need to consent, that obviously we can put in. So replacing the rules under 4.7, and then there's no resettlement at law, and the trust will keep the same vesting date. So the key things that we'll look at is leading member appointor means John Smith of 5 Smith Street. In the case of incapacity, resignation or death of this person, the next in line leading member appointer was Sally Smith, and then after that it goes to Bruce Smith. In the event that there is no leading member appointer, so everyone's dead, the trustee is off the roll to a beneficiary of the trust who is a descendant of the original leading member appointer. So we just go through there. Really, there's not a huge amount of changes. Most of it's pretty stock standard. I haven't got time to go into it, but let's just go through the beneficiaries. So we've got the leading member appointer. So that's John Smith. Any lineal descendant, child, grandchild, or great-grandchild of the leading member appointer. And then we've got in there too any other bloodline relative of any leading member appointer born before the termination date. We've got the bucket company. We've got a superannuation fund, so we can distribute straight to a superannuation fund, which would be non-arm's length income. You can go to a secondary trust as long as the beneficiary discretionary has it, and obviously benevolent objects as well. A natural person who's not a beneficiary under sub-clause may become a beneficiary, other where the trustee with consent leading member of writing so determines. So here I've done it with the leading member appointer. What I might do is I might go and also have a button there, which I've done in the discretionary trust as well, that the spouse can be included as well. Otherwise, and I'll tell you why a bit later, otherwise the spouse would come in under additional beneficiary because she's neither lineage nor is she bloodline of that. So it gives us a really good, strong, tight area. If you don't want that, then go and just get an ordinary discretionary trust. The rest of the stuff is income to fund. I mean, that's just distribution, so on and so forth, powers, etc. So it's all there. All gets signed at the end. by obviously the three parties, Smith nominees, which is the trustee, the leading member appointed, or John Smith has to agree to it, and also the appointed who has signed off that they give the consent. So that's your leading member discretionary trust. For those of you who are already LY strategist members, go and create one for yourself, or a variation or original one, and then you're off and running. So to find that, what we need to do is go to our product categories, and we'll be actually building a separate category here for leading member. But at the moment, what I've got here is in the trust. I'll go down here. You can start to see the big key one here is the leading member discretionary trust. So if you're starting it afresh and you want to go through that leading member, that's what you would use. As you can see, all our documents are $99. If you simply want to keep your existing deed and put a deed of succession of appointors, roll that one in there. If you want to add to the designated beneficiaries, just simply roll that one in there. Both of those are not resettlements. You'll need this a little bit later on, discretionary trust distribution minutes. Leading member discretionary trust variation, that sits there, as you can see. And as I said, you don't want to use a company, a leading member trustee company for a suit. Otherwise, whoever the leading member is going to bring their SMSF in as an in-house asset. We've also got up here for a non-foreign purchaser discretionary trust. We've got a leading member there. I know that quite a few people have basically used that as well. So have a look. That's particularly there's a surcharge or surcharge duties around Australia at the moment if your discretionary trust doesn't exclude foreign purchasers. So that's basically sitting there. So that's how I would use it. With the companies, so we'll use a corporate trustee. We've got about 10 minutes left. So with the companies, I've got an SMSF special purpose company. That's not the case. Company constitution variation to leading member SMSF corporate trustee. So that's a good one you can do now if you've got that. What I will do is working with our developers, I'll bundle this up. So if you've got an existing one, for example, John Smith, I would be bundling up there both the variation of the deed and also the variation of the company constitution there. We've got the leading member discretionary trustee company. That's if you're starting from the start. And then we've got the company constitution variation of LightYear Docs special purpose company. So one of the ones that I've got, we've still got to go through. So I'm taking you now to the guts of our back end. So this looks very like what you see in the LightYear Docs platform, and we haven't changed it. So this is one that will be launched. So it's a leading member corporate trustee for a discretionary trust. And what this is our hub. Just following, if you want to look on our hub, we've got a few things that I think is very exciting when I go down and have a look at a couple of things that are coming up in the history. Otherwise, most of you should know all that. We've got a couple of things coming up. Just in most of these you probably have seen there. We've got digital signing, which will come on probably in the next 3 months. We've got SOAs, which will be coming on very shortly. And what you've seen now that we're getting to. We've got a company pension compensation. I've got a sale of business coming up. The moat, which you guys have seen, I've actually got a bigger moat, which is coming out, and also the protector, which I think is really exciting. So I'll just call it protector. I want to get to the company quickly, but I just want to show you this. This is how I'm working on that. So the protector that I've got there is, so when we have a look at this, the protector is the documents involved there is establishing a trust, solvency certificate, deed of gift, promissory note, loan agreement, mortgage deed, personal guarantee. When wrapped up together, they effectively bring all of the equity you may have outside of an area. That will bring all the equity you might have in a personal home, investment property, shares outside, bring them all into a trust with a loan back. So effectively, it's the ultimate in asset protection. Buy-sell agreements. We actually, I think we do have a buy-sell agreement that's in the pipeline. So again, if you've got any issues, we've had a couple of clients. In fact, we had one the other day from Kush, I think, that asked for a bit of a change. We can turn them around really quickly. So if you've got a good, I've got a good template. Tony's got a couple ones for buy sell, so that will be coming down the track. I've certainly got a business sale agreement, and we've all got share sale agreements as well. But anyway, let's go back and have a look at so just go back in and have a look at the company. So I just go through the process. I've got the registration. I haven't done this on the site. The reason I haven't done, because otherwise I'm going to have to pay the asset fees because it's a new company compared to the constitution variation there. So I've got the registration, company details, Smith LMD nominees. Is it identical? Because it's just a trustee company, you're not going to have a business name. Limited by shares. We've got the registered office at 5 Smith Street, Sydney. Does the company occupy these premises? Yes. Principal office is the same. How many office holders? I've got two. Remember, it's John and also Sally Smith. So I've got the office holder here. I've got director and secretary being John Smith. I have to add another one now. So I'll just put in here, Smith. Oh, sorry. Smith. Sally. Again, I should be able to, I might be able to actually get the data from John. So I can pull that in there. I see how that changes there, and then I just put in Sally, just makes things easier. When you get a little bit later on, obviously once we set up this establishment, this will actually push all the data into BGL 360. So I've got the 20th of the 5th, 1974, and same. So we've got Sally there now. Leading member, who's the leading member? John, and also we've got John as the leading member, and we've also, that's all we need for this particular thing because Sally is the successor. Share structure, importantly, all the 100 shares, there's only one shareholder, and that is obviously the leading member themselves, and you'll see for a reason. So the member details, it automatically includes the individual as the shareholder. We put in that data there, there's no unpaid. Chairperson, John, and also public officer, John. Members' consent. So again, we can put in the date it's going to be consented to. Directors' meeting, we put in the date, but again, you put that in whenever we want. So we then go next, and then we would generate documents. So let's see what we've got popping out of here. So you can see this is much the same process. So I'm going to get the documents and we'll just look at these pretty quickly. So this comes to us in a Word, whereas for you guys, obviously, you get it in a PDF. That enables have a more sign on. Down here, also sharing, recovery. So what I've got there is, I'll just let up a bit. So the ASIC is pending. Again, as I said, this isn't one that I've been able to do on the site because otherwise I have to fork out the ASIC fee now that we're integrated with ASIC. So the leading member constitution of the nominees, all the stuff. I just want to take you through a couple of ones. So we've got the lineage, with the leading member is the appointor. We've got down here, it's really not a huge amount in terms of there. So we've got the company as a trustee of Discretionary Trust. The company will be incorporated for the major purpose of being the trustee of Discretionary Trust. If any provision is constituting conflict with the provision of the Corporations Act or regulation pursuant to that provision prevails. The company, apart from acting as trustee of the trust, is also ensured that as trustee, it operates for the benefit of lineage of the leading member appointor or such other persons in accordance with the leading member appointor's wishes. So they can come for the spouse and can also include the bloodline. And also, I've put it in here, you can be trustee of the trust, but not a trustee of a superannuation fund. So we've got the directors there. So a person is qualified and so forth. The director may assign as director, another director may be appointed in place, subject to consent of the leading member appointor. So then we've got the only person is director, leading member appointor, but we can put in another person under 5.3 if we wanted to have the spouse. And again, the leading member controls that. So the power of the directors is all okay, so there's no drama about that one. So lead member appointed as director of the company should act as the chairman of the company, has an absolute right of veto of all directors' decisions prior to resolution being finalised. We go down to meetings of directors, and again, it's going to be that number of directors or 50% of the balance of the stuff. When we go down a little bit further in here, so the sole shareholder company, only a leading member appointed the trust may be a shareholder of the company. So if you've got an existing company you're upgrading to this constitution, you want to make sure that only the leading member appointer has the shares. You'll see why very shortly. The leading member may not transfer their shares. Now, if the leading member dies, the company is immediately cancel the former leading member's appointed shares. So if we have a look at it, as soon as John dies, his shares are cancelled. At the same time, the company issue 100 shares of all the company's newly issued share capital to the successive leading member of the fund. So that would be Sally. So Sally would now be the sole shareholder. But if she's not around, then it goes to Bruce. So again, and then if he's not around, we have to go through that process again. So what we're doing is we're preventing those shares finding their way into the estate. So we're blocking it so that not only have we got asset protection for the trust throughout life, but also on death as well. And that also happens on bankruptcy as well, mental capacity, and also divorce. Now, I just want to go through, I can't guarantee it, but if we've got if we had inside the trust, we had the first leading member being John, and the second one being Bruce, because we're concerned about John and Sally's relationship, then what we would do is, as soon as there's a divorce, John would resign as leading member appointer. Bruce would take over. John would also resign as director of the corporate trustee. And now that Bruce is the leading member, what happens is it's now Bruce's lineage who's actually put in, or Bruce's bloodline. And that would now include, obviously, all John's children as well, and potentially John as well, but not Sally. So if we have a look at that, I can't guarantee it, but at least it's one way of potentially excluding. We can exclude under the deed John from being a beneficiary at all under that family trust, so that we could argue in court that there is no way that John is actually going to get those monies. So therefore the family trust should be excluded from divorce. So again, we put that in there in terms of the divorce. There's a couple of changes, but look, what I would suggest, and I love it, particularly someone like Milton, Felberg, etc. If you can download these and have a look and just really go through them and make sure that the process and systems I've built in there really fit. And because what we're trying to do is we're not trying, we're making sure that it's absolute protection. We're drawing that line, that red line in the sand. So as I said before, clean up your shareholding before you upgrade. Is there a bucket company? That's going to be quite a separate issue. Stamps for adding beneficiaries, etc. We have a good idea of what resettlement is, but we've just got to be careful, because you know what each stamp duty act is, or each duties act can be quite, can obviously be quite a concern there. So we need to have a look at that. What I'll do there is we'll just go to the final slide. Is there anything else you want to have a chat about, Tony?
Are you there? Are you there?
Yeah.
Sorry.
Yeah, is there anything else you want to have a chat about?
Look, if any, so if anybody wants, if anyone's got any issues rather on stamp duty or resettlements, etc., just give me an email basically, and I'm more than happy to assist in providing some advice around it.
Yeah, so I've just got from someone, what we will be doing is, so there's two ways of doing just around the resettlement issue. What we'll do there is that the standard document's $99, but if you also want to get a letter of advice around that, you can either go directly to Abbott-Family, or what we do intend on doing, because we have had a lot of requests, and thank you for this, it's almost like a Dorothy Dixer. For a lot of our bigger documents, particularly around the leading member, what we will do is effectively we will provide a letter of advice. It'll just be an extra couple of $100. So Tony and I are working on that one. And so instead of being $99, it'll be $299, depending on the quantum. Obviously the moat, etc., will be a little bit different. But thanks for that question. I've got a question here from Drew on how to register for the event. If you've got any client scenarios, please feel free. Again, if you want us to go through and have a look at the deed itself and make sure, but I think having a look at 2012/21 is pretty important. With a 2-day event, if we just get out of here, and I'll just take you just to a couple of things that are coming up, because I know we've had quite a few flurries of people who are concerned about their CPD coming up. So what I'll do is I'll just jump into I love SMSF. So I don't need that annotation. So I love SMSF. So if we just go there, up it'll pop there. So when you go to the site, you can see there the Succession and Estate Planning Conference. If you want to purchase the tickets, I'll just go through. We've got there, it goes through all the agenda, what we'll look at. Again, the key feature there is you're going to come out with an accreditation for that. Details. Now, the tickets there are, if you're already a strategist, you're a subscription or licensee, it's $545. But if you're early bird, there's $595. Now, I think so far that we have got about 12 people attending, and we can only have 30 people attending altogether. But look, it'll be a cracker of a 2-day conference. Have a look at that. Now, the other one that we've got events and webinars. So member CPD webinars. I know, Michael, you're still on. What I would suggest here, okay, so I've got to be logged in, so I'm not sure what my login is. I'm going to log on here. So I think Grant, I love SMSF. Oh, I don't even know what my login is. Sorry, guys. See if I can. Yeah, sorry, it doesn't look as though I've got that in there. But look, with if you go in and you're part of you're a LY strategist or you're getting CPD from us, then effectively, if you go in and have a look at the member CPD webinars, there's a whole range of webinars that are coming up between now and 30 June, which cover off ethics, companies regulation, covers off a whole lot of stuff under the FASEA guidelines. So just watch out for those. Make sure you attend all of those, but they're going to get your CPD FASEA hours. They're also accredited by the SMSF Association and also the FPA. But the main one we want is to make sure that they're covered by FASEA as well. But thank you very much for that question. Very good question, in fact. So we've looked at how to register. Again, look, thank you all for attending. Thanks again, Tony, for your wise words. And we will, as I said, I'll get this recording, send it out to you shortly, and make sure you go and have a play around with those leading members. And while I'm here, just go and have a look at the support centre. There's quite a treasure trove of information here. When I have a look at the strategy info and advice toolkits, there's a leading member case study, strategy text that you might want to use for leading member advice, and leading member data capture and client engagement letter for the leading member. So we've got a lot of stuff there, and that's all just a Word document which you can play around with. Anyway, it's Grant Abbott signing off, and thank you all for attending today's session. And I'll see you next week when we will be releasing, we may even be releasing the Protector either next week or the week after. Probably next week I might even just do the sale of business agreement. Anyway, it's Grant Abbott signing off.